Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Thank you so much for coming to hang out with me for a little bit of your morning. Today is Tuesday, January 21st, 2025, and it is a very chilly 6 degrees here in New York. It is bitter cold. Bitter cold. I'm sure it's cold maybe where you are too, except you guys are all over the world. So good morning. Going back to Florida today for a really interesting case. I mean, more interesting to me because the defendant is going to use the stand your ground law to try and have his case dismissed. So we're going to talk about that. Anybody know about this case? Anybody have no idea what I'm talking about? It's a country club incident. And the motion papers are interesting. We're going to look at the motion papers. A dentist who was playing golf with his 14-year-old son in Florida at a country club came upon a doctor and his wife walking on the golf course. They weren't playing golf, but they were walking on the golf course because they live in the development. It's one of those developments that's built on a golf course. Their home backs up to the back of the golf course, and they were walking on the cart path, and this doctor wasn't happy about that, and they got into a skirmish. And the dentist, it was a dentist, beat the doctor with a golf club. Didn't just beat him though. Like the guy sustained some really serious injuries, like a ripped off part of his ear, 5 fractured ribs, shattered his eye socket or shattered his nose and fractured his orbit, traumatic brain injury. Not just a little skirmish, but quite a melee. And so this has been going on for quite some time. Not really. I mean, April 2023. It's almost 2 years. Lake County, Florida. Looking at the court docket, there's been a lot of conferences, like plea conferences, but so far there's no plea. There's another one this afternoon. But tomorrow is going to be the stand your ground hearing. And the dentist is claiming that he had every right to fear for his life. He had every right to use the deadly force that he used, and his case should be dismissed. So that's interesting. And let's take a look. Yeah, I have the court doc. Oh, you've got the court doc. Was you, Cherie? Cherie is on it. The dentist is a complete loony, Cherie says, from down under. People say the dentist is a jerk. I also have an interview with the doctor who was walking on the golf course, so you can judge for yourselves. I don't know if this stand your ground hearing is going to be televised tomorrow. That remains to be seen, but we'll see. So let's take a look. Let's take a look first at the arrest report. Let's see, what should we do first? Let me just play this commercial from on Fox 35. There's a short clip, and we'll look at the arrest report, and we'll look at the motion, and then we'll look at the version, the doctor's version of the story, the victim, as it were. And in Florida, if the case is dismissed on stand your ground, the doctor will not have a civil case. The civil case is also dismissed, which is interesting because that's not the law in New York. In New York, even if the person is not convicted criminally, you can still pursue your civil case. So it's interesting. Let's give me a second while I listen to this ad so you don't have to hear it. How's everybody today? It's in Lake County, Florida, Harbor Hills Golf Course in Lady Lake. Yeah, walking on the cart path. Can you imagine? First, I thought he was walking on the fairway, and then I'm like, all right, well, I mean, he's walking on the fairway, That's that's a safety issue. But I mean, the guy's walking on the golf path with a cart path with his wife. So listen, here we go. Let's first watch the news piece so it can bring you up to speed a little bit. Then we'll look at the arrest report.
2 years ago, wants this case to go to trial, but the
Hold on.
man who was arrested for the attack says that he didn't start the
Rewind.
fight on the golf course.
Rewind. Okay. And go.
2 years ago, wants this case to go to trial, but the man who was arrested for the attack says that he didn't start the fight. Fox 35's Caroline Coles has an update on this case.
Nearly 2 years ago, a man was arrested for beating another man with a golf club. The suspect says he was defending himself. Meanwhile, that victim says he's still recovering from injuries. This path, once part of Joe Sivak's peaceful routine, has not felt the same since April 2023.
We're constantly watching our back. When we hear a golf cart, we jump. Just being here at home, neither of us sleeps very well anymore. We're always on edge.
2 years ago, Sivak and his wife were walking on this path.
He's going to testify at the stand your ground hearing, and I'm not really on board with him going on TV. This was Fox 35. He also did an interview with Jesse Weber at Law and Crime that we're going to look at. Maybe he shouldn't have done that because now he's going to be locked in kind of to what he said to these reporters, but he didn't ask me.
When they ran into Eddie Orobitg and his son playing golf. Deputies say Orobitg told the couple they were not supposed to be walking on the path because it is intended for golf carts. But then things allegedly turned violent when Orobitg allegedly spat in Sivak's face, then hitting him multiple times with his hands in a golf club. According to the affidavit, Orobitg continued to strike him several times as Sivak defended himself with a water bottle.
And then it kind of went downhill from there. It just didn't need to accelerate that way.
And what happened here left Sivak with more than just painful memories.
Are you willing to press charges for what happened? I think so, yeah.
You're looking at body cam video showing Sivak in the ambulance immediately after the alleged attack. Blood dripping down his face, visibly scarred.
I had nerve damage of what's called the infraorbital nerve here coming out of the eye socket bone, and I live with chronic pain.
Sivak also suffered from 5 broken ribs and 3 fractures in his face. He says he's still haunted by the attack.
At that point, I thought I was going to die or was dead.
The case now hinges on Florida's controversial stand your ground law. Orobitg claims he acted in self-defense. We reached out to his attorney who tells us, quote, the physical evidence does not support Mr. Sivak's version of events. Mr. Sivak's narrative has numerous inconsistencies and discrepancies when compared to the physical evidence in 911 call.
Well, here's the thing. He also had a traumatic brain injury as a result of this beating. So that's not really surprising.
Dr. Orobitg steadfastly maintains that he acted in self-defense. This is supported by the evidence. We are committed to presenting a vigorous defense that will demonstrate Dr. Orobitg's use of force was justified. And next week, a stand your ground hearing will determine if this was an unjustified attack or self-defense. Meanwhile, Joe says he just wants to see accountability. Reporting in Lake County tonight, I'm Caroline Coles, Fox 35 News.
Okay, so remember Ashley Benefield did not testify at her stand your ground hearing. That's why she was not allowed to use stand your ground. Her case was not dismissed on stand your ground.
commitment isn't
grounds.
just a word we
Stand your
throw
ground
around.
grounds. Because she didn't testify. So this guy's going to have to testify, the defendant, if he wants any chance of having his case dismissed in Florida. Let's take a look at the arresting affidavit. Because that's what we do here. We like documents. Here it is, folks. The arrest affidavit and appearance form in Lake County, Florida. Defendant's name is Eddie. I guess that's pronounced Orobitg. That's how they pronounce it on the news. Orobitg. Born in 1970, 5'9", 191 pounds. And he lives in Lady Lake, Florida. He's a member of this country club, a golf member. You're going to see a little bit of class warfare here because Dr. Orobitg is a golf member. And the victim, Dr. Sivak, is only a house member. If you know, you know. A little bit of class warfare here. Sometimes the golf members think they're better than the house members. Am I right? At least this guy does anyway. The date of arrest was April 30th of 2023 at 2:50 in the afternoon. And he's charged with aggravated battery, which is a felony in Florida. And this carries substantial jail time. The sentencing guidelines are so long that I couldn't figure out exactly how much jail time this could carry. But since it was like deadly force and this guy has really, really severe injuries, I'm going to say it's at least 5 years. And he was let out on $5,000 bond. And yes, it was in front of his son, which I find to be disturbing too. Somebody said that in the comments. And here is the probable cause affidavit. Signed by an officer named Polo, P-O-L-O, on the 30th day of April, 2023 in Lake County, Florida. The defendant did commit the offense of aggravated battery. On April 30th, 2023, at approximately 13:22 hours, I responded to the blank, which is the Harbor Hills Country Club, in reference to a battery in progress that involved golf clubs being used as weapons. Upon my arrival, I made contact with the victim, who stated that he was walking with his wife on the golf course path of their community when the defendant, Eddie Orobitg, advised him that he's not supposed to be walking on the golf course path as it is intended for golf carts and is a rule of the golf course. He stated that a verbal altercation then began between them, at which time the defendant struck him with a golf club on his leg and a physical altercation began between them. He stated then at some point that the defendant struck him with a golf club on the side of his head from behind, and that during the altercation, he defended himself by striking the defendant with his water bottle. He stated that the defendant continued to strike him several times and that he believes his ribs were broken. The victim was unable to complete a written statement. However, he gave up verbal intent to prosecute. While speaking with the victim, I observed his body and clothes covered in what appeared to be blood, and I observed him to have several cuts on his body, and it appeared as though his earlobe was ripped. He was treated on the scene by EMS and ultimately transported to the hospital for further evaluation due to potentially having broken ribs, potentially having a traumatic brain injury, as well as potentially having a broken jaw. I then made contact with other deputies who spoke with the defendant while I spoke with the victim, and they advised me that the defendant had stated that he was golfing with his son when the victim and his wife walked on the golf course, and he asked them to get out of the way. He stated that the victim then got into his face and shoved him. He stated that the victim then spat in his face, at which time a physical altercation began between them, and the victim struck him with a water bottle in the face and attempted to take his golf clubs. It says gold clubs, but we know that means golf clubs. He stated that he then believed that the victim was attempting to grab the golf club to strike him and his son. Therefore, he continued to strike the victim in order to prevent him from taking the golf clubs. And that's his side of the story until we get to the motion, because maybe we'll get some more detail. So, dentist. Did you like my thumbnail? Anti-dentite. Does anybody know what that's from? Anti-dentite. I know you know. Tell me if you know. He's an anti-dentite. The dentist says that the victim spit him first. Yeah, he says the victim was the one who spat in his face. And the victim says the other way around. Chuck Ward first in with the Seinfeld reference. If you know, you know. I think I can quote a Seinfeld episode or a Seinfeld reference for just about any situation. If any come to you while we're going over this besides the anti-dentite, let me know what you think. Also interesting is that in Florida, apparently you can take depositions in criminal cases. So there have been several depositions done of witnesses. Can't do that, I guess, in Massachusetts, because if they could, they would have been able to take witness depositions of, as such, the people at the waterfall. In the Karen Reed case, you think you were first on the Seinfeld? Wait, hold on. I'm going to go back and settle the bet. Let's see. I mean, I'm looking here, and the first person I see in here is Chuck Ward. Scorpion, you're second. Sorry, babe. And then Jen T, and then Aaron. So there were 4 of you in a row. Yeah, this whole thing never should have. Bad golf day gone worse. I mean, look, golf is frustrating enough as it is. Maybe it happened on the 11th tee. Maybe the good dentist was having a bad round, but that does not excuse a near fatal beating of a man who was just trying to get a little exercise with his wife in his own community. Rabid anti-dentite. No soup for you. No soup for you. In some states, spitting is assault. Yes. Well, that's the victim's story, is that dentist spit at him first. But I guess we're going to hear testimony tomorrow. If it's televised, we'll see. All right, moving on. The deputies also advised me that they made contact with the defendant's juvenile son who witnessed the incident. So his 14-year-old son was in the golf cart with him. I think his 14-year-old son was driving the golf cart. He stated that he and his father were golfing when the victim and his wife were walking on the golf course, and his dad asked them to get out of the way. He stated that the victim then got into his father's face, and a verbal altercation began between them, at which time his father spat in the victim's face, and the victim retaliated by spitting back in his father's face. Okay, so the son is telling the truth and saying that his father started the altercation by spitting in the other man's face first, which is interesting. Enlarge my font here. He then stated that the victim pushed his father, and in the process of getting pushed, his father accidentally struck the victim. His father accidentally struck the victim with his golf club while he was falling. However, he dropped the club when he got up. He then stated that his father and the victim began physically fighting, and his father began to strike the victim several times, even when the victim was on the ground. All right, well, this kid is not getting involved. He's telling the truth. Good on him. While on scene, I did not observe the defendant to have any marks on him that are consistent with being struck. I did observe him to have a cut on his hand and what appeared to be blood on his clothes. I further observed his golf clubs to have what appeared to be blood on them. I then made contact with the victim's wife, who provided a statement that corroborated the one provided by the victim. She stated that the defendant first spat in the victim's face, which is what caused the physical altercation to begin. Due to the statements provided by the subjects on scene and the evidence that was observed, the defendant was taken into custody and transported to the Lake County Jail without incident. Nothing further at this time. So he's taken to the Lake County Pokey, and then he's bonded with $5,000, and he's let out. And here we are, nearly 2 years later, and they've made a motion to dismiss, which we're going to take a look at next. Yeah, insanely uncalled for, you think? You think? A little bit. Yeah, it was a severe beating. We're going to look at an interview with the victim after this, and you'll see. He talks about it. One of his ribs was shattered. 5 fractured ribs. I mean, you got to be beaten pretty severely to fracture 5 ribs with a golf club. It wasn't a baseball bat. It was a golf club. I don't know which club it was, mean, I guess if it was a driver, it could have done more damage than, maybe a wedge, but maybe not. So this is interesting because this motion was made all the way back in August of 2024. It's just being heard now. I think they've been trying to work out a plea deal, but so far no dice on the plea deal. Is it still road rage if you're driving a golf court? It's path rage. Path rage. Livy says, man babies, men having tantrums. But also to do this in front of your son. Deposition question. Did you yell for before you took a swing at your neighbor? Well done. Well done, Team Brittany. Well done. Also in Florida, the jury gets to ask questions. This stand your ground hearing won't be in front of a jury, but it is another fun fact about Florida. And we've seen that in many cases, right? Name some where the jury, Florida does allow jury questions, right? Now I'm getting confused, but I think they do. I'm thinking Sarah Boone. I don't think they asked questions. Did they ask questions in Sarah Boone? Correct me if I'm wrong. I could be conflating my cases. Bice is a Florida resident and says, the day should come when stand your ground law will be repealed, in my opinion. This and the popcorn movie murder case are ridiculous. I think in some cases it might be appropriate, but I think when it gets overused by defendants, it becomes a problem. Teed off, new meaning to the term teed off. Well done. Not that, Susan. Well done. All golf puns are welcome. This is the funniest chat on the internet, and you guys know it. You guys know it. Teed off. He was teed off. You know what? Can I steal that for maybe a thumbnail? I had anti-dentite in today's, but I think teed off is an amazing one. On the 11th tee. Thank you, Not That, Susan. You get full faith and credit for that suggestion. Love it. Tellis was in Vegas, right? I don't remember any questions in the Benefield case. I know that it's like at the judge's discretion, because the judge is the gatekeeper and all. And so there are certain states that allow jury questions. I'm trying to. He thought he was club worthy. Aaron, well done. Well done. Oh, well done. Very good. Very good. All right, here we go. This is the state of Florida against Eddie Cha Orobitg, who's a dentist. Motion to dismiss based upon self-defense immunity. Comes now the defendant Eddie Cha Orobitg by and through the undersigned attorney pursuant to section 776.032 Florida statutes and Florida Rule of Criminal Procedure 3.190 and moves the court to find that the defendant is entitled to immunity from criminal prosecution and dismiss the charges in this case. That's right. Maya's case. Maya's judge allowed questions. She was in Florida. That was also a civil case. Yes. Okay. So I am correct. Thank you. In support of this motion, the defendant would show the defendant, Eddie Orobitg, was arrested on April 30th, 2023 by law enforcement and charged with aggravated battery, which is a second-degree felony under statute number 784.0451A1. This incident occurred on the Harbor Hills Golf Course with the nearest roadway being Spinnaker Loop in Lady Lake, Florida. The specific location was on the tee box and adjoining the section of golf cart path of the 11th hole of the aforementioned golf course. Eddie Orobitg and his son, T, I'm going to call him T for now because he's only 14 years old and I can't even imagine, well, it's an unusual last name, so I'm sure his schoolmates know who he is, but it's probably kind of embarrassing for him. Age 14 are members in good standing of the Harbor Hills Golf and Country Club, and as such were invitees on the course for purposes of playing golf. Eddie Orobitg has been an active member of Harbor Hills Golf Club for the last 19 years. Eddie Cha-Cha-Cha. Eddie Cha-Cha-Cha. I agree. Annie, Florida resident. Stand your ground should remain. Remember Ashley Benefield? Yes. She's got a bond hearing this week. That's the purpose of the defense. It is. It is. Eddie Orobitg and T. Orobitg reside within the Harbor Hills community. Eddie Orobitg's date of birth is May of 1970. He was a lieutenant in the United States Navy and was honorably discharged. A photocopy of his DD-214 is attached as Exhibit A. Eddie Orobitg is a licensed and practicing dentist, DMD, and had his office in Leesburg, Florida for the last 25 years. He's been married for 33 years to his high school sweetheart, and he's the father of 3 children. I'm not quite sure how any of that makes him any less of a felon, but okay. At the time of the incident, Eddie Orobitg and T. Orobitg were utilizing the property of the Harbor Hills Golf Course for its intended purpose with the express permission of the club management. Upon arriving at the 11th hole tee box, Eddie and T. Orobitg observed Lorraine Sivak and Joseph Sivak walking on the 11th fairway. Okay, I think that's where it's going to differ. There's a difference between walking on the fairway and walking on the path. And even the police report says they were on the cart path, so we'll see. They had no golf equipment and are impeding the intended use of the property by their presence in the field of play. Okay, this is one thing that I hate. You know, I'm a grammar snob and a punctuation snob and a misspelling snob when it comes to legal pleadings. They're going to vacillate in between present tense and past tense in their narrative of what happened here. And it just, for some reason, it just really bothers me. It's like nails on a chalkboard. So I didn't write this. They wrote it. It's not me. They had no golf equipment and are impeding the intended use of the property by their presence in the field of play. The golf club has clearly marked no trespassing signs for all persons who are not authorized golfers. See Exhibit B here too. Harbor Hills Golf Club has a dress code for golfers. Here we go. The dress code includes the wearing of a collared shirt and having the shirt tucked in. Joseph Sivak, well, it's Sivak, was clearly not in compliance with the dress code and as such, obviously not a golfer. Joseph Sivak was dressed in basketball shorts and a wife beater style tank top, clearly marking him as a person in a place in which he is not supposed to be. The Sivaks lacked any equipment for the game of golf. Maybe I should read with a less snark because I got so many comments the other day about how my snarky, rude reading of Justin Baldoni's complaint was so offensive. So maybe I should read that again with no snark. Harbor Hills Golf Club has a dress code for golfers. The dress code includes the wearing of a collared shirt and having the shirt tucked in. Joseph Sivak was clearly not in compliance with the dress code and as such, obviously not a golfer. Joseph Sivak was dressed in basketball shorts and a wife beater style tank top, clearly marking him as a person in a place which he is not supposed to be. The Sivaks lacked any equipment in the game of golf for the game of golf. I don't know. I just can't do it that way. And also, if you want to listen to a robot voice or an AI voice reading stuff to you, maybe you're in the wrong place. That's what I say. Oh my God. Akasha, you have no idea. You have no idea. Free the snark. Free the snark. Plaid pants and white leather belts only, says Crow Red Eye. You know. Giovanni's Pikachu. You cannot wear that attire at the club. No, you can't. I just think that it is in poor taste for somebody to put, in quotes, wife beater style tank top in a legal pleading. He could have just said he was wearing a tank top. Right? I don't know if we're going to see Mr. Sivak in the, I think we do see him a little bit in the body cam when he's in the ambulance. So we'll see if we call that a wife beater tank top. Yeah, I just think that's in poor taste. I mean, personally, I don't think that men should wear tank tops anyway, but I think calling it a wife beater is also a little bit misogynistic. That's just my opinion, though. That's what you're here for, right? My opinions. Eddie Orobitg calls out to the trespassers who are 60 yards away and facing the opposite direction. The identities of the trespassers and their intentions are unknown to Eddie Orobitg at this time. Thanks, Deb. Deb came for the snark. Joseph Sivak immediately turns around and begins waving his arms in an aggressive manner and yelling unintelligibly. He's carrying a hard plastic water bottle of approximately 40 ounces. See Exhibit C. Joseph Sivak walks aggressively back towards the 11th tee box. His unintelligible words clarify as he walks into a stream of profanities. Oh, as he walks into a stream of profanities. Eddie Orobitg maintains his position on the 11th tee box and does not advance. Trevor Orobitg retreats to the far side of the tee box, staying behind his father in response to Joseph Sivak's aggressive advance. The tee box is elevated from the ground beneath it by approximately 3 feet. Joseph Sivak steps up to the tee box and shoves Eddie Orobitg, saying, "Duck you." Eddie Orobitg regained his balance and leaned into Joseph Sivak. See, now it's in past tense, and before it was in present tense. I don't like that. Joseph Sivak shouted, "You just hit me with your golf club." Eddie Orobitg replied, "You're ducking, psycho," and spat on Joseph Sivak. Okay, so even in this motion, he's admitting that he spits first. And he admits that Joseph Sivak was yelling, or these, according to him, walking aggressively, cursing at him. And then the defendant admits right here that he spits on him. Joseph Sivak responds with a violent swing of his 40-ounce water bottle, striking Eddie Orobitg in the right temporal forehead. Eddie Orobitg regains his balance and punches Joseph Sivak in the face. The water bottle strike dislodges Eddie Orobitg's prescription sunglasses. Eddie Orobitg is severely nearsighted and unable to see anything other than shapes at any distance. See Exhibit D. I can't see. It wasn't my fault. I didn't mean to hit you. I didn't know it was you. Hold on. I gotta go. Witness Keith Bostaff, whose home is located near the incident location, observed Lorraine Sivak unsuccessfully attempting to hold Joseph Sivak back from storming the tee box by physically holding the back of his shirt. The wife beater tank. The actual incident was not observed by witness Bostaff due to foliage blocking his view as he was mowing his lawn. See witness Bostaff's deposition transcript attached here too as Exhibit E, consisting of 2 pages, specifically at page 12, lines 8 to 18, page 18, lines 7 to 19. Eddie Orobitg responds by punching Joseph Sivak. Joseph Sivak falls backwards from the tee box onto the cart path. Joseph Sivak sustains an injury to his ear, either by the punch or his head striking the concrete. I mean, he's admitting his assault in these papers. But Eddie Orobitg loses balance with the punch and falls to the concrete along with Joseph Sivak. At this point, both men are grappling on the ground. Eddie Orobitg sustains injuries to his knees and abdomen. See Exhibit F, consisting of 7 pages, attached here too. Eddie Orobitg then disengages and stands back up. Joseph Sivak immediately gets up to re-engage his attack upon Eddie Orobitg. Eddie Orobitg strikes Joseph Sivak as Joseph Sivak is charging Eddie Orobitg's punches. Charging his punches? This replays multiple times. Joseph Sivak and Eddie Orobitg began to then kick one another. Eddie Orobitg is using his foot to keep Joseph Sivak back. Eddie Orobitg can be heard on the 911 call telling Joseph Sivak to stay down. Eddie Orobitg begins holding Joseph Sivak back with his foot to stay away from striking distance. The men continue to tussle and fight as evidenced by Lorraine Sivak's 911 statement. They won't stop fighting. We're going to hear a little bit of that 911 call. Joseph Sivak ultimately regains his feet. Regains his feet. Maybe he regains his footing. I don't know. And attempts to grab. When I'm reading these pleadings, I'm always rewriting them in my head. I know. It's a problem. Joseph Sivak ultimately regains his feet and attempts to grab a golf club from Eddie Orobitg's golf bag in order to strike Eddie Orobitg. Joseph Sivak pulls a club from the bag, and Eddie Orobitg pushes him to the ground and uses his foot to leverage the club from Joseph Sivak's hands. Eddie Orobitg then pushes Joseph Sivak away from the golf clubs and back to the ground. The shafts of several clubs. There should not be an apostrophe there. See this misplaced apostrophe? The shaft of several clubs bear Joseph Sivak's blood from his attempt to arm himself with a club. See Exhibit G, attached, consisting of 3 pages. Oh, yes, that's true. Golf clubs are really deadly, says Cape Cod. Ask Martha Moxley. Oh, my gosh. Remember that case? Good morning, Crafty Chris. Does that work? I'll try not to curse. I don't curse anyway. I'm always correcting the grammar. I do. It upsets me greatly because as a lawyer who's written many, many things, legal pleadings in my life, I'm always meticulous. And sometimes you need another set of eyes. So, look it over, make sure there's nothing misspelled or grammatically incorrect, but they didn't ask me. Upon separation of the parties, Joseph Sivak enters Eddie Orobitg's golf cart to arm himself with golf balls, which he throws at the son before walking away. Uh-oh, he went into another man's golf cart. I mean, there's got to be a problem with that, right? Ask Tiger Woods about golf clubs being swung at you, says Marie. Mm-hmm. Yep. Look at Kim picking it out that they've misspelled Joseph several times. You're picking up what I'm laying down here. Oh, well done, Kevin, the Sally Poor camera. What is a golfer's worst nightmare? The bogeyman. Well done, well done. In this case, Orobitg was the bogeyman. I'll leave it now. No, you don't have to leave now. I'm going to use that too. Bogeyman. I think he might have been having a bad round is what I'm thinking too. More golfers in the chat. I'm a golfer. I actually have a hole-in-one. I know, I hate to brag, but there is actually a plaque with my name on it in the clubhouse. 116 yards with a 7-iron. You know. All right. No, it was an 8-iron. Sorry, it was an 8-iron. It was 116 yards. And I had a witness too, so there's that. Joseph Sivak gave the objective impression of a mentally deranged individual. His mental instability is evidenced by his actions that day, as well as his multiple statements in deposition of his belief that Eddie Orobitg was going to sexually assault his wife. Oh. Has this caused a wedge between them? Martin Smallwood, well done. Causing a wedge. Caused a wedge. You guys are real. You are the best. This is the funniest chat on YouTube, and you are. It's like a tough crowd here because everyone's in competition to have the best puns. Team Brittany, at least no one involved is named Mulligan. That alone would start a conspiracy theory. Well done, well done. Hi, Olivia. This is in April of 2023, but tomorrow is the Stand Your Ground hearing in which this dentist is going to try and have this case dismissed because, in his opinion, he used justifiable force in Florida, which may or may not dismiss his case. But if it didn't get Ashley Benefield's case dismissed, you can let me know whether you think this guy should be able to use Stand Your Ground. Everyone. That goes to everyone. Sivak is the victim. Orobitg is the dentist who is the defendant. Okay. Oh, Mystery and Eddie. That's great. What was the driver for this altercation? Well done, well done, well done. Oh, you guys are amazing. Squirty Belly says, when I golfed, I kept score of how many balls I lost. Ah, you're fantastic. Fantastic. All right. So apparently during the deposition, Joseph Sivak said that he thought that the dentist was going to sexually assault his wife. And so therefore, I think that proves that he is in fact an anti-dentite. If you know, you know. Joseph Sivak was later involved in an altercation with his roommate in the hospital, further evidencing his aggression and mental instability during this time period. Oh my goodness. See the court filed under seal. Therefore, he must be crazy because he was involved in an altercation with his roommate. But also, he had a traumatic brain injury. So, you know, if you know anybody with a traumatic brain injury, it can definitely affect your personality and your penchant for violence and such things like that. Patience. So that'll be interesting. This just keeps getting more interesting. What was the lake effect in all this? Well done. Well done, Mama Suri. Well done. Right, Emmy? This is all after he got the TBI. Mm-hmm. We're going to need a golf emoji. We are. What was the lake effect? Oh, you guys are so funny. Amy's like, I love the snark and comedy. I look for your streams daily just in case YouTube doesn't let me. Good. Good. Make sure that you have the subscribe button hit and that you have the notifications set to all and that you enable the notifications on your phone from YouTube because sometimes that may be why you're not getting them. Oh, it was his roommate in the hospital, Lamisa Filipino Food Club. So it was his, she says, why does he have a roommate with a wife, I wonder? This was his roommate in the hospital. So I don't know how long he was in the hospital for, but he had, yes, a TBI can change a person completely. It absolutely can. I represented many clients with TBIs, and a lot of them led to divorce. You know, in particular, one I can think of was a construction worker who fell off a roof, and it was bad. It was bad. He was like a completely different person after. Personality changes are not uncommon. A loudmouth. He was told to go pound sand. Summer says it's social butterflies involved in this tea with a teacup. Well done. Well done. Okay. Here's the law in Florida. Like it or not, let me get my red pen out because I don't think I got marking up this far. You know how much I love a red pen. This is going to teach us once again the stand your ground law in Florida. 776.012 Florida statute says use or threatened use of force in defense of person. A person is justified in using or threatening to use force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. Okay, others' imminent use of unlawful force. So this is justifiable use of force except deadly force. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. And that's what they mean by stand your ground. So there's no duty to retreat. And this differs by states. Many states do have a duty to retreat before you're allowed to use force against another, unless you're in your own home. Here in Florida, it doesn't matter where you are. You don't have a duty to retreat if you feel that you are being threatened. Oh, Martin. So it must not have been his rescue club. Well done. I love my rescue club. It's gotten me out of a lot of trouble. Rescued me many times. 2, a person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another person, or to prevent the imminent commission of a forcible felony. So this has to do with deadly force. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. Oh, thanks, Ricky Watson, for being here for 12 months and being happy about it. Thank you so much. OG, Selena says, wow, wild story has been with me for 7 months. Chadzia, thank you for your super chat, who comes in with some more snark. Are you sure it was 5 broken ribs, not 4? F-O-R-E. Well done, my dear. Thank you for the super chat. And on top, thank you, as always, for your super sticker. Under Florida Statute 776.031, use or threatened use of force in defense of property. A person is justified in using or threatening to use force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to prevent or terminate the other's trespass on or other tortious or criminal interference with either real property other than a dwelling or personal property lawfully in his or her possession or in the possession of another who is a member of his or her immediate family or household, or of a person whose property he or she has a legal duty to protect. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. So Florida also allows you to use force in defending not only your person or other people, but also your property. Kale, thanks for your super chat. Says, come for the snarks, stay for the facts. Love it. Subpar behavior, says intolerant, who's been here for 9 months. She gets it. Subpar behavior. I'm writing all these down because you guys are amazing. All right. I'm on a roll. Where's the hole? Says quack, quack, quack. 2. This is still under use or threatened use of force in defense of property. A person is justified in using or threatening to use deadly force only if he or she reasonably believes that such conduct is necessary to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. Florida Statute 776.032 provides immunity from criminal prosecution and civil action for justifiable use or threatened use of force. A person who uses or threatens to use such force as permitted in the statutes that we just read is justified in such conduct and is immune from criminal prosecution and civil action for the use or threatened use of such force by the person, personal representative, or heirs of the person against whom the force was used or threatened, unless the person against whom the force was used or threatened is a law enforcement officer who is acting in the performance of his or her official duties, and the officer identified himself or herself in accordance with any applicable law, or the person using or threatening to use force knew or reasonably should have known that that person was a law enforcement officer. As used in this subsection, the term criminal prosecution includes arresting, detaining in custody, and charging or prosecuting the defendant. Look at Sarah and Shock and Heart gifted 10 memberships. Thank you, Sarah. Sarah is one of the amazing moderators of this channel. Also, an incredibly kind human being. And welcome to the 10 new members. I think you're going to like it here. Thank you, Sarah. You are so very kind and generous. Always, always. And here's the memorandum of law. A, the Stand Your Ground framework. This motion is filed pursuant to the aforementioned Florida Rule of Criminal Procedure 3.190B and 3.190C3, pursuant to the procedure established in the Florida Supreme Court case of Dennis v. Slate. That Supreme Court held that the judge was to hear testimony and make a decision based upon the evidentiary standard and not simply order the motion dismissed. If the state files a traverse or a demur, copy attached. The procedure contained in Dentist v. State is the appropriate procedure to follow in the instant case. However, the evidentiary standards have changed in the Florida statute. Florida Statute 776.0324, 2017 became the law in Florida on June 9th of 2017. This law provides, in a criminal prosecution, once a prima facie case of self-defense immunity from criminal prosecution has been raised by the defendant at a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the party seeking to overcome the immunity from criminal prosecution provided in subsection 1, evidence added. So when the defendant raises stand your ground as a defense, the burden shifts to the prosecution to prove that he was not justified in using the deadly force. I mean, I would argue that this is deadly force. I mean, he probably could have killed the guy with that golf club. The facts in this case happened on or about April 30th, 2023. As such, the current Florida statute applies, thus changing the burden of proof to the state of Florida in this matter. Florida's stand your ground law confers immunity from criminal prosecution and civil liability. See, that's very different than New York. And I think most other states. If anybody knows another state where this applies, let me know. Which means that if the case is dismissed on stand your ground, the doctor does not have a civil case for personal injury against the dentist. Ducati girl, did the victim see birdies afterwards? Great. Well done. Squirty Belly David Reese coming in with a 5 says, I still don't understand how Ashley Benefield wasn't allowed stand your ground. Well, her case was not dismissed on stand your ground on a stand your ground defense because she didn't testify at the stand your ground hearing, and therefore the judge felt that there was not enough evidence to dismiss it at that point. But she did use it at trial because she did testify, but that's the reason it was not dismissed pre-trial, because she didn't testify. And so there wasn't enough evidence according to the judge, Judge White. Andrea, thanks for being here for 5 months. His best 5 months on YouTube so far. Irish wishes, sláinte, my friends. Ireland is watching because Andrea Collins is just one of the many friends that we have from Ireland in this chat. So Florida's stand your ground law confers immunity from criminal prosecution and civil liability without the obligation to retreat on those who use or threaten to use force, reasonably believing that such use of force is necessary to defend himself against another's imminent use of unlawful force. And then they cite the Florida statute that says that. An objective standard is applied to determine whether the immunity provided by these provisions attaches. Montanez holds that in determining whether the immunity accorded by Section 776.032 attaches, the objective reasonable person standard by which claims of justifiable use of deadly force are measured should be applied. Both sections of Florida Statute 776.012 further provides a person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. Consequently, if a person is in a place that they lawfully have a right to be, and they are confronted with any type of force, deadly or not, the person no longer has a duty to retreat and can defend themselves. Deadly force can be utilized if necessary based upon the situation. Once a prima facie claim of self-defense has been raised, the state must prove by clear and convincing evidence that the defendant is not entitled to immunity. When a party has the burden of proving any claim or defense by clear and convincing evidence, it means that the party must present evidence that leaves you with a firm belief or conviction that it is highly probable that the factual contentions of the claim or defense are true. Okay, compare that with other standards like preponderance of the evidence, which basically just means if the scales of justice are like this, preponderance of the evidence is just a little bit tipping the scales, just a little tiny bit. Beyond a reasonable doubt means that there is no doubt that you believe the defendant committed this crime. Clear and convincing evidence means that you have a firm belief or conviction that it is highly probable that the factual contentions of the claim or defense are true. Highly probable. A deadly weapon, it must have been a shank, says Martin Smallwood. Gets it. Kelly did not foresee that coming. Trish says, I doubt a water bottle is a deadly weapon. Big Bertha will be a witness. Team Brittany. Team Brittany, you're coming in hot this morning, girl. Have you had a lot of coffee? Do you know my tea order? If you know, you know. Which doctor lost his grip? Well done, Mama Suri. Well done. Well done. According to the Supreme Court in Colorado v. New Mexico, clear and convincing means that the evidence is highly and substantially more likely to be true than untrue. In other words, the fact finder must be convinced that the contention is highly probable. Argument. Eddie Orobitg used lawful force. Well, we don't know what kind of water bottle it was yet. We're talking about the water bottle. People said, what if it's like a Yeti? What if it's like one of those Yeti things that's like a big metal thing? Some of those are heavy, right? I don't know if it was a plastic bottle. We're going to see when we get to hopefully the exhibit is attached. Snark Tank is on fire today. Argument. Eddie Orobitg used lawful force as permitted by Florida laws, and is therefore immune from criminal prosecution. Eddie Orobitg was permitted under Florida law to defend himself from the unlawful use of force by Joseph Sivak, and Eddie Orobitg had no duty to retreat before doing so. Eddie Orobitg was in a location for which he had a right to be. He was golfing with his son on a golf course for which they are both members. Joseph and Lorraine Sivak were trespassers. Get off my golf course. Oh, wait, what happened here? Trespassers. The entrances to the course are clearly marked with no trespassing signs. Even if believed that they did not see the no trespassing signs, the Sivaks know that they were not golfing and were in a place that they had no right to be. While Eddie and Trevor Orobitg were in the location that they were lawfully allowed to be, Joseph Sivak approached them aggressively. Witness Bostaff observed Lorraine Sivak attempting to physically restrain Joseph Sivak from charging the tee box while Eddie and Trevor Orobitg were upon it. We contend that Joseph Sivak creates the first contact, however, with an aggressive approach in that manner. Eddie Orobitg would be justified and immune from prosecution for defending, what happened here? Himself with any type of non-deadly force. Within the first moments of the altercation, Joseph Sivak introduces deadly force by striking Eddie Orobitg in the head with a 40-ounce water bottle. This is admitted by Joseph Sivak. At this point, Eddie Orobitg is justified in the use of deadly force to defend himself and his son. However, he maintains the use of non-deadly force in defending himself and Trevor Orobitg. So he says, I was justified to use deadly force because he hit me with his water bottle, but I didn't use deadly force. I only used non-deadly force in any event, but I would have been justified in using deadly force. Instead of using deadly force, Eddie Orobitg punches Joseph Sivak. As the tee box is elevated, Sivak falls back approximately 3 feet onto the cement. I just want to point out also, cement, and you can correct me if I'm wrong. Wouldn't the proper term be like concrete? Because isn't cement wet? I don't know. It's one of the things I've picked up through my many, many years of life. I may be wrong. Eddie Orobitg continues his use of non-deadly force by keeping Joseph Sivak on the ground as Joseph Sivak attempts to continue his attack. Joseph Sivak ultimately trespasses onto the property of Eddie Orobitg by going onto his golf cart and into his golf bag in order to arm himself with a golf club with which to strike Eddie Orobitg. This is evidenced by Joseph Sivak's admission, Lorraine Sivak's written statement, and the blood on the shafts of the golf clubs. Or maybe the blood was on the golf clubs because you beat him bloody. I don't know. Remains to be seen. Eddie Orobitg is further justified in any use of deadly force against Joseph Sivak based upon this burglary of a conveyance for the purpose of arming himself with a deadly weapon. Joseph Sivak's admitted purpose of arming himself with a club was to strike Eddie Orobitg. Cement is an ingredient of concrete. Cement is finished. But is cement the dried product? Like would you call it a cement path or a concrete path? Golfboy UK. Cement has only sand as the aggregate. I'm a geologist specializing in foundations. Thank you, thank you, thank you. I appreciate you. I was afraid of the bogeyman. Well done, well done. Once the parties separate, Joseph Sivak again burglarizes Eddie Orobitg's conveyance in order to get a golf ball in order to throw it at Eddie and Trevor Orobitg, thus committing another assault and battery against this family. In determining whether the state has met their burden of showing evidence that is highly and substantially more likely to be true than untrue. I don't think that's a complete sentence. In determining whether the state has met their burden of showing evidence that is highly and substantially more likely to be true than untrue, period. The court will have to judge the credibility of the witnesses. Why is this not being a continuous scroll? Eddie and Trevor Orobitg have been consistent in their statements from the beginning. Joseph and Lorraine Sivak have changed their stories with every retelling. They've repeatedly used the excitement of the event for their lack of consistency. The Sivak statements in the 911 call are wholly irreconcilable with their current testimony and with what the independent witness observed. Eddie Orobitg's legal right to self-defense was complete at the time that Joseph Sivak broke away from his wife's grasp to charge the tee box. This act was objectively observable as a hostile act, creating immediate need for Eddie Orobitg to use force to defend against the attack of Joseph Sivak. Any subsequent action by Eddie Orobitg after the initial attack, and especially after being struck with the water bottle, and any subsequent physicality, was statutorily authorized, thus providing him immunity from subsequent prosecution. Therefore, assuming that the altercation was the proximate cause of Joseph Sivak's injury, Eddie Orobitg cannot be prosecuted and is entitled to immunity from criminal prosecution and dismissal of the pending charges. Wherefore, Eddie Orobitg respectfully requests that this honorable court enter an order finding entitlement to immunity from criminal prosecution and dismissing the criminal prosecution in this case. Martin's a golfer. Was the golf ball the pinnacle of the assault? Well done. Okay. Wherefore, Eddie Orobitg respectfully requests that this honorable court enter an order finding entitlement to immunity from criminal prosecution and dismissing the criminal prosecution in this case. XOXO. Nicholas Stack out of Tavares, Florida, attorney for the Good Dentist. And this here is his discharge from the Navy. I don't know why that makes him a more credible witness, but there's his record. Here is Exhibit B, the no trespassing sign. No trespassing on Harbor Hills Golf Course. Violators will be prosecuted. Exhibit C. Well, we have to look at it like this. But this appears to be the water bottle. It's hard to see what it's made of, whether it's one of those neoprene like plastic ones or if it's like a metal one. I can't tell by looking at that. And they don't say what it is. I mean, if it was metal, don't you think they would have said that in the papers? And if it was empty and it was plastic, would it have hurt that badly? Here is Eddie's here's Eddie's prescription for his glasses that he just had done in June of 2024, which was a year later. And I don't know how to read a prescription, but he's claiming that his eyesight's really bad and he can only see shapes. Any eye doctors in the chat or optometrists? That's Exhibit D. And this is Exhibit E. This is Keith's deposition, the witness. All right. Well, I think we should read it while we're here. So it starts with what is the end of a question by an attorney. Box with the woman holding his shirt. Answer, I did not really see them approaching. I saw them once they were there. Question, okay, so you don't know exactly what direction. Tell me exactly what you saw with regard to that person and the woman. Answer, I saw when they were up there. I saw him apparently trying to approach the tee box. I saw him walking away afterwards. Question, and when he was apparently trying to approach the tee box, you said that the woman was holding his shirt. Can you describe that? Answer, had the back of the t-shirt kind of like holding him back. I figured it was just some golfers fooling around. At that point, that was my impression. Question, was it the lower part of his shirt? Was it around the collar? Answer, the lower part of his shirt, belt line area, a little above. Question, could you see the man's face? Answer, not well enough. Question, all right, could you tell me whether or not the person was agitated? Answer, I could not tell you that. That would be a guess. Come on back. Oh, well, you know what? I think I read the second page first. Well, that was page 18. Okay, then on page 13. Well, this is page 12. So this was before in the questioning. This is his narrative, the witness. So half the time I'm going away, half the time I'm going towards. The majority of the time I'm going towards, I'm still looking at the grass, stay in line, but I glance up constantly. Cannot see the tee box in the summer because of the bushes and the shrubs and everything else. I can see where the golf cart path is next to it. There's a ball wash station. Got to wash your balls. Very important in the game of golf. Tee. There's information on the tee. I did not see when Eddie did go up to the tee box. I saw where he had gotten off the golf cart path and gone up to the tee box. A few minutes later, I saw another couple on the golf cart path next to the tee box talking to someone on the tee box. The only other thing that I did see is at one point I did see the gentleman that was on the golf cart path seeming to approach the tee box. And the woman had the back of his shirt and was kind of holding him. And at that point, I turned around to do another row. So I think he's mowing his lawn. Come back. They can't see. Oh, wait, come back. Can't see anyone again. Go back again. Come back. They're walking down the golf cart path. So the interaction itself, question. Okay. Answer. I can't say. So those are two portions of the testimony of Keith, the witness. This is Exhibit F. I don't remember what this is supposed to be a picture of. No idea. This looks to be a knee. Looks to be some injuries to, I guess, the good dentist's knee. And a belly. I don't know what that's supposed to show. A belly. This is exhibit. Appears to be maybe a bruise and another scratch on the belly. And some other bruising maybe, or dirt. I mean, it looks like it could be dirt. I'm not quite sure. And some bruising down here by the boxer shorts. Boxer shorts waistband. And Emmy says that doesn't say she was holding him back, just that she was holding him. He might have been hurt already. Meant to, thanks, Emmy. Robin says, yikes, how is he a practicing dentist with that eyesight? Hope he has a disclaimer on his new patient forms. My ex is a dentist, so I know there are magnifiers, but this is a little extreme. Dunya Shabismuth says, so you're telling me there's a machine that does it for us now? Yes, it is very, very important because dirty balls can be their own hazard, says Mama Suri. You know, when you're golfing, you got to make sure your balls are clean. I could go on for days with golf buns. Here's another picture of the belly or his side. Another picture, more pictures of his side. And a picture of the golf clubs with some blood on them. This one and this one. Blood on the 4-iron. On the outside of the head, as it were. And what is this? Looks like maybe a 52-degree wedge, but I don't know. I don't know what he's pointing out here. I don't see any blood, unless there's blood and we just can't see it. And here's the deposition of Joseph, the victim. Joseph says, starting in the middle of his narrative, and it was towards the end, I think it was somewhere around when she was getting 911 on the phone. I tried to grab one too, if you will. Make the defense a little more even. He was attacking me with a weapon, an iron golf club, and all I could think of is, I can't get away from this guy because I can't run because I could hardly breathe. I had no idea how injured I was. So yes, I admit I tried to grab it. There was no going after his son as the assailant. Your defense, your client says, oh, I knew. This is his quote, at least from the videos I see. I knew. I don't know how he knew, but he says, I knew he was going to attack me and my son. Why in the name of God would I attack a child, let alone him? I just wanted to get out of there, and I couldn't run from him at that point. And thank God Lorraine did get 911 on the phone, put the speakerphone on, because I believe he would have killed me. And yes, I don't know if he would have hurt Lorraine or sexually assaulted her. He was deranged. He was deranged. Oh, so he did mention that he didn't know if he was going to sexually assault his wife. You can't even make this stuff up, you guys. You just can't. Question, the purpose of trying to get the golf club would be to hit Mr. Orobitg? Answer, no. The purpose of that was to defend myself. So that was page 56. That was page 72 first, then page 56. All right, they're going, well, I don't know what they're doing here. This is the end of another narrative. And I stumbled, somehow I was near the golf cart at this point, and I tried to reach for a golf club because I remember my brain, saying, and again, it's very confusing, but I was 100% convinced that he was going to kill me. And I was 100% convinced he was going to attack my wife. And I did not know if he was going to sexually assault my wife. My brain was just trying to get what was happening, but I saw he had the golf club. I think it was in his right hand. I tried to grab him because my brain said, all right, you've got to survive. He's going to kill you. He's going to kill Lorraine. Do something. I didn't know what to do. I had no weapon. So I tried to grab one of his golf clubs. I pointed to his, or I sort of motioned golf club. And the strangest thing, he looked at the golf club at that point, and he looked at me like twice. He did like a double take, and he violently threw the club on the ground and continued hitting me at that point. But that was, I think, towards the end when Lorraine finally got a hold of 911. Question, did you get a golf? Answer, never, absolutely not. I tried to grab one. All right, so this is from Joseph Sivak deposition on February 28th of 2024. Did the witness see it or just hear a ping? Martin, you're on fire today. Robin says, essay is the last thing on a golfer's mind, especially one golfing with his son. What a real hole in one. Did I bite him? Yeah, I bet him says. And remember, this is subsequent to his traumatic brain injury. So there's that. Is that the end? Okay, I just wanted to go back for a minute. We'll go to the chat. Oops. And then we're going to, let's see what that was supposed to be a picture of. That exhibit that we looked at. We couldn't tell what it was. Talk amongst yourselves for a second. All right, so that was exhibit F. Let's talk amongst yourselves for a second. Exhibit B, exhibit C, D, F. Eddie Orobitg sustains injuries to his knees and abdomen. See exhibit F, consisting of 7 pages. Okay, so I don't know what that picture was supposed to be of part of his body, but it was too poor quality in its Xeroxed form for us to be able to tell what it was. Hello, what's going on with my computer? Hello. Well, technical difficulties, but what else is new? It's Tuesday. It feels like Monday, but it's really Tuesday. Squirty Valley says, but the burden's on the prosecution to prove it was not stand your ground. That is correct. You are correct in that assessment. Well done to you. Thank you, Kevin. The Sally Port camera became a new member. Welcome, welcome. Did I bite him? Yeah, I bit him. Says, get your best tea here. Like and subscribe. Oh, thank you. Thank you so much via Super Chat. Did I bite him? Yeah, I bet him. Said this guy spends more time in the sand than David Hasselhoff. Oh, you guys are fantastic. You guys are so funny. You're so funny. All right, let's get to the this is some of the body cam. Also, the interview that the good doctor gave to Jesse Weber of Law and Crime. I don't know why I can't get this thing to close over here, because if I freeze up, you guys, I'll be right back. Don't worry. I'll be right back if it happens. I don't know if it's going to happen, but you never know. Let's see if I can fix it this way. Nope. Go away, be gone, be gone. All right. Well, 'tis what it is. My second screen is all fakakta. It's all fakakta. Is it the tiger move? I don't know. All right, here we go. Here's the interview he did with Jesse Weber of Law and Crime. I like Jesse Weber.
Whatever. All right.
I'll put the captions on so you can see them. Don't rely on them because
But evidence and witnesses have posted that you started the physical portion of it, okay? Hence the reason why you're being arrested, okay?
Two doctors have two radically different versions of what went down on a golf course 2 years ago that left one man seriously injured. We're going to speak with this alleged victim in this case, get his side of the story as the alleged attacker prepares to argue self-defense at an upcoming Stand Your Ground hearing. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Golf is supposed to be relaxing, right?
okay, so he talks a little bit about the facts, which we already did. So we're going to fast forward through his version of that to the 911 call.
911, did you an ambulance?
911! We are having an altercation on the golf course.
Okay, do you know the address?
We need somebody now.
Okay, ma'am, what is the address that you're located at? Ma'am, what address are you located at? I can't send help to you if I don't know where you are.
Yep. I can't give you the address.
Okay, what golf course are you at? Ma'am, what golf course are you at?
Oh! Stop it! Oh my God! They just won't stop!
Okay, well, what's going on, ma'am?
They're fighting with golf clubs, kicking the shit out of each other.
When Lake County Sheriff's deputies arrived on the scene, they found Dr. Sivak distressed, badly injured, bloody. His son actually took a video on his phone of what was going on.
And he hit him, and then he just kept kicking him in the ribs.
After he was on the ground.
After he was on the ground. And it
So remember, they live in the community. Their house backs onto the golf course, and apparently the dentist, the defendant, Dr. Orobitg, also lives in the community. I guess they didn't know each other, so I guess their son, Sivak's son, was able to come over and he made a video. I think he said it was the victim's son, right? Hold on.
Buddy, his son actually took a video on his phone of what was going on.
And he hit him, and then he just kept kicking him in the ribs.
After he was on the ground.
After he was on the ground. And it was really not a nice way to fight.
Body cam footage obtained by Law and Crime revealed that Dr. Orobitg was actually surprised when deputies placed him under arrest.
He's surprised.
This is unbelievable.
Yeah, I wasn't lying to you, brother. I honestly didn't know until they walked over here and said
Why
something.
am I being arrested, sir?
I was 22-year-old woman, okay?
He legit has no idea. Like he beat the bejesus out of this guy. What do you see this guy like in the ambulance? 5 fractured ribs. One of them was shattered, in addition to facial fractures and a traumatic brain injury. And he has no idea. This is ridiculous. Why are you arresting me? I'm a member of this golf club. He clearly doesn't belong here because he's wearing a wife beater tank top. And there's a dress code here.
Don't be nice and give you 2 handcuffs. All right, reason you're being arrested, okay? Yeah, you guys got into a mutual combat, okay, argument or whatever. All right, but evidence and witnesses have posted that you started the physical portion of it, okay? Hence the reason why you're being arrested, okay?
By the way, not to take away from the seriousness of this case in any way, but look, I got to tell you guys about something. I am very excited because we have...
Okay, he's going to do an ad, and then we're going to get to his interview with Joseph Sivak, which comes up now.
Son from an unprovoked attack by Dr. Sivak, that he was merely expected physical harm. They don't have to flee. Dr. Orobitg's defense team is expected to argue that he was acting within his rights under the law, maintaining that he was merely protecting himself and his son from an unprovoked attack by Dr. Sivak. All right, so with all that in mind, I want to bring on a special guest. I want to bring on Dr. Joseph Sivak. So thank you so much for taking the time to come on here. I was telling this before we started. I know this is not easy. recounting what happened and talking about this. So thank you for coming on. Appreciate you taking the time. If you can, I think the best place to start is to just briefly go through your version of events of what happened.
Right. Well, it's, there's so many details. It's hard to talk about it briefly, but, basically, my wife and I have been walking for years. We went out.
Okay, he's a talker. He's a talker, like Kerry Roberts is a talker. This guy's a talker. Not the greatest idea to go on law and crime before you're going to need to testify at the stand your ground hearing, and you've already given a deposition, but he didn't consult me before giving this interview. But I guess he wants his story out there, so we're going to listen to it. Just take it back a second.
There's so many details. It's hard to talk about it briefly, but basically, my wife and I have been walking for years. We went out to take one of our normal walks. The path we were taking was something we'd taken probably a couple hundred times since the pandemic. The golf cart paths, the golf course goes through our neighborhood. We were about a 10-minute walk from our house. It was a happy day. At any rate, we were finishing our walk out on the path and coming back to finish our walk.
Did he just say it was a happy day? It was a happy day, like a Sarah Boone happy day. Is that a Florida thing? It was a happy day. It was a really good day. It was a really good day. Did some arts and crafts. We did some puzzles and we were crafted out.
And we heard a golf cart coming up behind us really, really fast. And the golf cart paths, we're not on the golf course. We're on the path that goes out to, I guess, where they tee off. It's a concrete cement sidewalk. We heard someone coming up fast and yelling from behind, "Get the F out of here, get the F off the golf course, get the F out of here." Just vitriolic, vile language, yelling, swearing at us. So we startled, kind of scared, both turned around and saw this golf cart approaching with a man in his, didn't know it at the time, but it was his son. It was like a teenager, 13, 14, 15 years old, driving the golf cart. I waved like this sort of to flag him that I heard him. He was probably 20, 30 feet behind us. And I waved and said, sorry, we're getting out of here, we're leaving. And mind you, we had walked this path.
Here's the thing. Just step off the path. Step off the path onto the grass and let the guy go by, right? I mean, that's what I'm thinking. Like, why are you saying, hey, we'll be out of your way in a minute? Just step off the path and let him go by. But you can see he's a talker. I might even speed him up a little bit because he talks a lot. Let me see.
Many times, as I said, hundreds of times, and occasionally, maybe 10% of the time, we pass a golf cart coming on to the golf course and sort of, wave, get out of the way, how you doing, kind of, have a nice day, good round, whatever. Never had any issues or problems. We had, go ahead.
Can I ask you about that real quick? So just to make sure, no one ever said, hey, you're breaking the rules. You're not allowed to be on this this pathway. Is it against the rules at this golf course? Do you know?
I've never seen anything. We were members for 8 years in good standing of the country club, social members. There's different levels of membership. We went to events.
They were social members. They were only allowed to eat and play pickleball, maybe tennis.
The country club, we weren't golfers, but tennis, pickleball, dinners, all that kind of stuff we had access to. We were pretty low-key active members, never had an issue. And in all those years of walking these paths, never had anybody, reprimand or say it's against the rules. I never saw anything in writing that said you couldn't. Now the person that attacked me cited that there's a no trespassing sign, but it says for Harbor Hills. We live in Harbor Hills. One of the fairways, butts up to our backyard where, trees are, and we cut our lawn, and it's right on the golf course. It ends and starts there. I mean, the parameters, the boundaries are kind of vague, but it's funny because I just was looking at a card I got from a neighbor a couple weeks after the attack. And it said, we and our guests have often taken walks along the golf cart path. Never would occur to me that the crazy loon neighbor or on would yell at me and beat me with a golf club. At any rate, we've heard from many people. This isn't unusual for people that live in the neighborhood.
So he starts, according to you, he starts yelling at you, telling you to get off. What happens next?
Oh, yeah. He wasn't telling us he was swearing and yelling at us. It wasn't, it wasn't, could you please move? Would you like to move?
There's the dentist mugshot. I wonder if he'll use that on his website. Who here is an anti-dentite?
Move or get, it was vitriolic, threatening language with lots of profanity directed at us. So there was no way to get off of this golf cart path the way it is without going past the golf cart where he parked. So we had to walk towards him, about 20, 30 feet.
No, the mugshot was the blind dentist. This is the doctor, who I think is a psychiatrist, that he alleged, that was beaten, or that was a participant in the melee.
Feet and walk past him.
The victim, if you will.
Him. And we had said, we're leaving. He said, you have no right to be here. And again, I had no idea who this person was. I again, didn't know. He didn't seem to represent, the Harbor Hills Country Club or anything. But we started to walk past him. He got out of the golf cart and started following us. We got past his golf cart. We're a few feet ahead and he's following us. And we're leaving. It was clear we're walking towards the street and the sidewalk and the homes to be off of this path. But he kept following. And I turned and I said, what are you going to do? We're leaving. Are you going to attack us from behind? It was very, very terrifying and threatening. I hadn't ever experienced anything like this. And we were clearly past, and it was quite obvious we were leaving. I turned around and picked up the pace even more. My wife is walking, next to me or a couple feet in front of me, keeps following. I turn around again and I said, stop following. We stood there eye to eye, probably 2-3 feet apart. And he's literally on my heels and I turned. He stood there. I stood there.
This is a totally different story than the dentist tells in his papers, because he says he was on the tee box, right? When they had the altercation.
He spits in my face, and it wasn't, it was like I had to clear my eyes. It was just a real, hawker spit in my face. I wiped my eyes.
Let me just stop you right there.
It's a hawk in his face. And he had to wipe the spit out of his eyes. It's revolting. And Jesse's like, I give Jesse so much credit because he's trying to he knows this guy's a talker clearly, and he's trying to move the story along. It's like, yeah, and making a short story even longer.
You didn't spit at him first. You didn't shove him first. Oh, God,
no. And in fact, in the police report, and even his son said in the police report by Officer Deputy Polo, his son said that he spit at me first. I mean, it was the first, affront of anything. I've never had anybody spit in my face like that. So I wiped it, out of my eyes. He hit me. He had a golf club in his right hand, and he hit me in the leg, the lower leg, kind of above my knee, with his golf club, and then shoved me.
Okay, here's his tank top. See if we can enlarge this at all so you guys can see it better. But
at that point,
he's wearing a tank top. This is not what I would call a wife beater tee. To me, the wife beater tee is like the Hanes one that comes in the package of 3. That's tight and white. This looks to be a tank top with some sort of writing on it. I can't read what it says. Can't make it big enough to read what it says. My opinion.
I had a plastic water bottle in my hand,
Plastic.
hooked around my finger, and after he
It was plastic, the water bottle. That answers the question.
Shoved me, I'm like, Lorraine, he spit at me. My wife is, 10, 20 feet away, and I'm like, I didn't know what was going to happen, and I'm not a fighter. I've spent my whole life, all my adult life, 35 years, taking care of patients. I'm actually a physician, a medical doctor, and I've been a psychiatrist, worked with veterans for years, homeless population, indigent patients. That's what I spent my life and my vocation doing. I don't try to hurt people. And if I had hurt somebody as much as I was hurt and did that to someone, I don't know how I could live with myself.
Oh, look at his face in the hospital. I mean, he's really banged up. This isn't like no joke. Apparently they had to stitch his earlobe back on. Yikes. Yeah, he got a haircut since then.
But spits on me, hits me, shoves me. I swung at him, and again, I'm not a fighter. I swung the golf or the water bottle sort of goes flying because it was just a little plastic hook at the top around my finger. So I swung, sort of grazed his head. I think his hair. I didn't really connect. Missed the water bottle.
Wait, let's take a look. Somebody said that the dentist's shirt was untucked, and that is a violation of the club rules. And he's wearing a collared shirt. There are golf courses that do not allow you to wear shorts. You must wear slacks. He didn't say that in his rules of dress code, but he did say your shirt had to be collared and tucked in.
It comes off the little plastic thing holding it on, and that goes flying somewhere. And at that point, I swung, again, I missed. I sort of grazed him. And somewhere at that point, I turned again to get away after I swung, turned away, and I saw the golf club coming, or a shaft, a piece of metal, like a rod coming at me. Next thing I know, I'm on the ground trying to get up, feeling the side of my head and my ear, and there's blood everywhere down my arm, and it's on my hand. And I tried to stand up, but I didn't know how long I'd been out. And the other thing, and this is really gross and humiliating, but I know I lost consciousness because right when I was hit, everything sort of went black, and I felt myself lose control, almost like you're having a seizure, lose control of my bowels and bladder. That has never, ever happened to me in my life. Anything remotely is resembled.
It's really embarrassing, but he lost control of his bladder and his bowels, and that is horrible and horrific, and that is usually an indication of a very severe injury and or unconsciousness. I think it happens also at the time of death. But Ducati Girl points out that this doctor failed the shut-up classes, as Kathy would say, from Gossip Rumor and Innuendo. And yes, 100% he failed the shut-up classes. He keeps talking.
That. So it's a terrible thing, humiliating. I'm down. I try to stand up, and I don't remember much after that except getting just hit and knocked back to the ground. I remember the things I remember, and I don't know if it was 2 minutes or 5 minutes. You sort of lose track of time. I remember going out, like blacked out from being hit at least 3 more times. I remember trying to stand up. I never really swung again. I remember being on the ground and seeing and just looking at the sky. And initially it hurt, but after a point, it was like watching a show or a movie of just these fists coming in my face. And I wasn't even feeling the pain anymore because I ended up with a concussion and a traumatic brain injury. And there's a point where, you're getting clubbed into unconsciousness over and over. You don't even feel pain. It's like anesthesia because you're out. So I remember that. I remember trying to stand up. My legs were, I was all over the place, unbalanced, I guess. Don't remember much of it, but I remember my wife screaming at this person, telling him to stop. And at one point she stood, right up to me, as much larger than her. And I stood up, and I remember pushing my wife back because he lunged at her, and I thought he was going to attack or assault or do something to her. And I shoved her back.
Sexually assault her. That's what you said in your deposition. Listen, he's a talker. It doesn't mean he deserved to be beaten nearly to death. And luckily, luckily, there's going to be no jury at this stand your ground hearing. It's going to be a judicial decision. So we'll see. But here he goes. He's going to keep talking.
I said, "You're not going to attack my wife," and again, getting hit and being on the ground again. I remember him having the golf club in his hand, and I remember pointing at it and trying to grab a golf club to defend myself, because I thought at one point I thought I was not even alive. I thought I was dead, or I thought I was going to die. I tried to grab a golf club from the back of his golf cart, reaching for that, never got it. But I remember him looking at me to hit me again, and then looking at the golf club and he threw it down really, really violently on the ground. It's like he didn't even know it was in his hand. But I, at that point, somehow got hit again. I'm on the ground. I remember one other thing I remember is being on the ground, being kicked in the side over and over again, and trying to grab his leg to get him to stop or pull him down, because it must have been 5 or 10 or 20 kicks in the side on the ground. But I remember just being hit over and over again on my back.
Yeah.
So, and just seeing the sky and just seeing these fists coming in my face.
I mean, that is just an absolutely harrowing account. I was hoping, and I'm so sorry, what the injuries you sustained and what you went through. And I want to just clarify that a little bit. You said you suffered, a brain injury. Talk to us about what injuries you sustained, and also how has that affected you to this day?
Yeah, so it's going on 2 years for this case, and the injuries I sustained from the attack, I actually had 5 broken ribs, 5 fractured ribs on my left side. One of them was comminuted, which means shattered into many pieces. In my face, I had about 25 to 30 stitches in my ear. My earlobe was coming off. My face, I had.
I mean, he really ripped his earlobe off.
Around my eye, the orbit bone, the rim of that was fractured. My nasal bone right here was depressed and again shattered into pieces, and my jawbone here was fractured. I had nerve damage from what's called the infraorbital nerve coming out, and I have chronic pain right here in my face and jaw and teeth that never really goes away. It's because that's from the nerve damage. That nerve got kind of crushed that comes out from the eye socket. The traumatic brain injury, saw a neurologist about that. They said a moderate traumatic brain injury, losing consciousness. 4 times, being hit over and over again in the head. I have problems with my balance. My hearing is worse. I had some hearing loss over the years, but much worse. My vision.
Oh, he had some hearing loss before the incident, so maybe he couldn't hear the good dentist yelling at him to get off the path. Interesting.
I've had more problems with that. And the PTSD, post-traumatic stress disorder, suffering with. My wife is struggling with that too, because she witnessed the whole thing. She was terrified. But nightmares, bad memories, and most of all, we're not the same. Neither of us feel safe. We're tense, we're anxious, on edge, irritable all the time. And just, we can't ever relax. It's like there's no peace. There's no joy. We don't laugh anymore. We don't really feel safe. In the neighborhood, we try to overcome it and desensitize ourselves and take walks, but very difficult to do. Headaches, like I said, my balance is off. All kinds of pains through my temples and shooting pains, and it's sort of awful.
Doctor, talking about what you're talking about, and now hearing that the defendant in this case, Dr. Orobitg, is claiming self-defense, that he has an upcoming stand your ground hearing. How does that make you feel? His version of events.
It's like the whole thing is happening over again. This stand your ground. I can't really, talk about the case. I guess it's not surprising. there's no.
Well, you've really talked about the case a lot, and that's the problem, is that you've given a deposition, you're going to testify at the stand your ground hearing, and now you've given this version of events, not only on Law and Crime, but also on that other piece that we watched earlier from another news station. So you kind of have talked about the case a lot.
There was he didn't try to help. He didn't call 911. I look at the police axon videos of all this. He refers to me afterwards as quote to the police officer, between you and I, he's meaning me. He's a woke piece of. He's crazy. He's a psychologist, So just to see.
He called him woke. This is what happened.
See that and wondering who or what. We're not particularly political. I've certainly never been called woke. I've never been called anything. My wife and I are very low key about politics, but he must have thought, I stood for something that was detestable to him, to call me those names and so much anger.
He didn't know you. He didn't know you before this. You didn't know him.
I had no idea who it was. When I found out later in the hospital, they said he was released on bond. I don't know how long he was in jail, and they said his name. Then I knew of him who it was, but I had no idea at the time. But yeah, I believe he knew me, or thought he knew me, or thought he knew who I was. I'm not a psychologist. Again, I'm a physician, but psychiatrists and psychologists.
Right. With the stand your ground hearing coming up, is this something that you're going to attend? Are you going to testify at?
Yeah, I've been, and my wife has too also. I mean, we're witnesses, we've been, it's in the docket, we've been subpoenaed. I guess, and I'll just talk in generalities about the stand your ground law, because I never understood this, and I don't know how it works in other states. But with stand your ground, this is you file this, it's a motion to basically dismiss or throw the criminal case out based on stand your ground. In Florida, stand your ground, if a defendant is charged with a crime, prevails or wins that case, that person, the way the Florida law is written, is then immune from any civil action. So, for example, if a victim had $50,000 or $100,000 in medical bills and they wanted to sue the person that victimized them, you can't, based on what would happen in the criminal case in the stand your.
No civil case allowed if stand your ground dismisses this case. In my opinion, I don't think it's going to. Oh, thank you for loving the title of my stream. Yes, anti-dentite. He's an anti-dentite. That's it. He was called woke. That's the end of that. So the stand your ground hearing is tomorrow. I do not know if it's going to be televised. I don't know. I'm going to be on a plane tomorrow to an undisclosed location. But if you are interested and the hearing is televised, or I can find a video of it when I get to my location, I would be happy to watch the stand your ground hearing with you. So let me know in the comments if you're interested in this case. I found it to be quite interesting on many reasons, because I think we need sort of a palate cleanser case that nobody can really be incredibly divisive on. I saw a little bit of divisiveness in the chat, but we're not laughing at what happened here. We're trying to make some golf puns. That's what we were doing here today. So anybody who doesn't know this chat or this channel, there's nothing funny about this. This man was beaten, really, and it could have been beaten to death, quite frankly. Whether or not this dentist should get off and have the case dismissed on stand your ground remains to be seen. In my opinion, I do not think that he should be allowed to use stand your ground, but you never know what's going to happen in Florida, do you? You never know what's going to happen. Ashley Benefield was not believable to the jury. And so let's see, in this case, what happens. Make sure you hit the subscribe button. Make sure you hit the bell and have all notifications set, because I don't know. I just have a feeling that some stuff is going to come out today on Karen Reed, or maybe some other things that we're going to need to talk about later, in which case I may just go right on. So you want to make sure you have your notifications on. David Reese says there hasn't been a golf fight like this since Happy Gilmore and Bob Barker. Thanks, you're 5. And I love Adam Sandler, and I love all things Adam Sandler. And I'm also a big Caddyshack fan too. So there's that. Thank you, moderators, for keeping it classy today. It is not always easy when we cover cases, but this one should have not been too difficult. Members, I love you. You're my cupcakes. Viewers, replay viewers, I love you too, just as much. Smash the like button. Help a girl out. Smash the subscribe button. It's free. And as always, stay cool, stay kind, stay classy. I know you guys can do it. I know you can. Maybe I'll see you later and we'll see what happens today. Peace, my friends. Enjoy the rest of your day.